where dignitaries from various fields of law are invited to speak on relevant topics of law in the form of an enriching seminar being held offline for the first time. The previous 5 episodes were held online due to the restrictions posed to the pandemic. The webinar aims to interest the students of Xavier Law School in an intriguing talk session. The topic for today's episode is space law as a career option. Presiding over Colawquia Episode 6, we have with us today honorary speaker Professor Dr. Sandeepa Bhat. He is a professor of law at the West Bengal National University of Juridical Sciences and is the director of the Center for Aviation and Space Laws. I now invite and request the Dean of Xavier Law School to felicitate Professor Dr. Sandeepa Bhat with a memento as a token of sincere gratitude for his gracious presence and share a few words.
Good afternoon, sir. We are really grateful to sir today that he has come to visit us and to address all our students, and within the short span of time he has accepted our invitation. I am really grateful to him, and once again thank you, sir.
I now take this opportunity to invite and request Professor Dr. Sandeepa Bhat to address the students of Xavier Law School and enlighten them as to how space laws can be a viable career option.
Something special for today because actually this is actually the first lecture in the beginning of the 20th year of my career, and I just completed 19 years yesterday, and this is actually the 20th year of my academic career, and this happens to be the first lecture on the 20th year. Thank you so much for the invitation, and it's also a great privilege to speak on actually career in space law. Right, so that's always actually I try to pursue, and also I try to actually advocate for different people. Now I think every student here actually, you might not be interested much in the classes, right? Of course, who is actually interested in hearing others? Everybody is actually interested in speaking, but nobody is interested in hearing others. That's always actually a kind of a problem for everyone. That we can understand as a human behavior as such actually. Keeping a focus of actually maybe 1 hour or 45 minutes or whatever it may be in every class is a difficult task. But is there anyone who is not concerned about career? Don't you want a good career at least? Everyone, isn't it? Everyone is concerned about actually a good career, whether actually you would like to put forward the hard work or not, right? So everyone has his own limitations or his own perspective. So therefore, we can't debate on that. But at least with respect to career, everyone is actually optimistic, right? You would like to do something, you would like to make something. Now, when I say about career, first thing maybe which comes to your mind is that okay, maybe criminal law has got a good practice, consumer law, right? A lot of consumer cases are actually happening. Motor vehicle accidents, no doubt, right? A lot of actually the cases are coming up. Right? actually your specialization. Many more might be interested in actually technology law coming up. So of course everyone is interested in actually having a good career. Is there anyone in this class who has thought about space law as a career option? Anyone? Yes?
It is one of my options.
Please be seated. Please feel comfortable. Right? So no need to stand and all. Yeah. So it's one of your options. What do you mean by that?
Sorry.
Somewhere at the bottom. Right. So you have at the top some 3, 4, 5.
Yes.
Bottom somewhere actually yes, space law might work for you.
Yes.
Right. Anyone else?
Maybe after the seminar.
Maybe yes.
Maybe after the seminar.
After the seminar, okay, right? No, that you can't actually predict it right now. After this, it might be a disastrous thing. You might say that no, let me not hear this for once more actually. So you might say that. That's a different thing. Right? You have an intention. There is no career option in space law in India, so therefore actually you don't feel it's worth to try for. Absolutely right. So you're right. I should say that. Especially for someone who is sitting in this corner of the world, in India, right, or maybe most of our Asian counterparts, obviously it's a problem. We can't actually visualize a career in space law. Right? And I completely agree with the majority's view here that space law is not an option for you. But let me tell you that it's a myth. It's a myth, especially because we are in a world where the private space activities have not kick-started much. You might have heard about some news about actually say some private enterprises investing in the space in India, etc., etc. Yes, of course. Yes, there has been actually investments, but that has been very, very limited. Very limited in the sense only in terms of maybe say operations like say direct television broadcasting, remote sensing, right? All these peripheral space activities. You have actually got some kind of investment in India. But whereas the main activity like say launch, operation, controlling the satellite and the return of the space objects whenever there is a requirement, you don't have investments. You don't have private space launch facilities operating in India. Right? That is why this lack of investment in the private sector is something actually showing us a kind of a wrong signal in terms of a career in space law. Right? There is no much investment as of now. So precisely because of that reason, the problem is that we are not in a position to find a kind of a practical implication of space law in India. But that is not the truth across the world. Right? So make preliminary research. I mean, I'm not telling you to actually go in depth into that. Just make a preliminary research after this, maybe this session. I mean, I would like to have it as an interactive session rather than the one-way dialogue as such. So just make a preliminary research, find out how many private entities are having the launch facilities in the western part of the world. They don't launch facilities. India, you have only ISRO launch facility. You might have heard about SpaceX, Virgin Galactic, Armadillo Corporation, Blue Origins, right? They all own their launch facility, private launch facilities, right? So there are many such kind of actual corporations who have got their own actually. You like to communicate something? Right. So there are many such private entities who have got their own launch facility and operation facility, etc. And in those places, there will be a lot of litigations. There will obviously be a lot of litigations. There will obviously be a lot of practical applications of the space law. I should also tell you one more thing. Why that we are not having much private investment? Everyone knows that from India operating is cheap. Like our labor charges, service charges are actually very competitive. Maybe China can match with us, but apart from that, most other countries in the world can't match with the cheap labor and cheap service facilities available in India. But still, why there is no much private investment in India? Why there is no much private investment? I should say the lack of law, lack of legislation. Right? Despite all efforts and everything, till today we could not pass a national space legislation. Why is this important? This is important for the purpose of giving clarity about what is the extent of liability of the private operator. Is it an unlimited liability or are we going to cap the liability? If you look into most countries, they have come up with a cap of the liability, right? So that the remaining liability will be taken care of by the states, right? Whenever actually the any kind of a mishap occurs over and above a particular limit, the state takes care of the liability. Then insurance coverage. In order to meet the liability in case of a mishap, what kind of an insurance requirement need to be met with? That need to be mentioned in the national legislation. If all these things are not there, then the private players would not be knowing how exactly to deal with this liability issue, how exactly to actually take the insurance coverage, so on and so forth. Right? That is the basic problem. So that is the reason why, unless and until a national legislation is in place, private players are skeptical in terms of investment. Of course, we have got a 2017 draft. I don't know how many of you have gone through it actually. There's a 2017 draft National Space Bill. There were actually problems, there were some actually limitations. 2022, the new draft is actually coming up now currently. I'm part of actually the drafting committee. 4 of us have been made as the part of the drafting committee. Hopefully this draft actually would conceptualize. We have already handed it over to the ISRO chairperson. So hopefully it actually conceptualizes. And if it conceptualizes, I'm pretty sure that we will be having more and more private investment in the XSLAJ. And more private investments would definitely mean more and more litigations. Right? More and more litigations. Once actually the private investments starts to take place, you would definitely be able to find out more and more litigations in this way. So this is what is actually the scenario. As of now, we are not having actually the much awareness, primarily because actually we don't have these private space activities much. But western part of the, forget about only western part, even Australia for that matter. Make some research, even Google would help you, right? Find out launch facilities are there in Australia. Lot of litigations, and there are different law firms which are practicing also exclusively in the space law. Not an exaggeration. I know my own friends, many of my own overseas friends, they are heading their law firms, right? Working in space law. And let me tell you, my friends, each litigation in space law is worth of multi-billion dollars. Multi-billion dollars. Investment is like that in space sector. So a very small percentage of actually the litigation stake, whatever is there, would make a lifetime for not just a lawyer but for a law firm. Right? That kind of actually the investment is there. Have you heard about Anthrax divorce case? Anthrax Corporation and Divorce Corporation with respect to the orbit and spectrum licensing and all. Anthrax versus divorce. No? One of the biggest cases, you definitely should understand that, right? Anthrax Corporation is the Indian corporation with respect to privatization of the space applications. They have actually given actually the leasing of certain spectrum to Divorce Corporation. Lot of irregularities were there, so therefore actually the leasing has been cancelled, resulting in huge loss to Divorce. Right? And the case ensued at the international arbitration level, and the Permanent Court of International Arbitration has awarded more than 1,000 crore compensation to the Divorce Corporation. Government of India is liable to pay more than 1,000 crores as per the arbitral award as of now, and we are thinking how to escape from this huge liability. There is no good lawyer to actually litigate this as of now. Right? So that is one instance. And these kind of instances are many in the western part of the world, as well as actually the places like Australia or even Japan. Japan has started now. Japan has started the space activities now, private space activities. So you can find out that in those jurisdictions, there is actually a lot of scope for the lot of scope for the practice in the space law. Right? There are abundant number of the firms also practicing in this particular field. So that's why, let me tell you that there is definite career option available in the space law. And with this base, let me tell you what are the major areas. Right? So let me supplement my argument. Right? So why am I saying that these are the areas wherein you have got good scope for the purpose of practice, or maybe actually making your career. First is licensing and contracts. If you look into the international treaty obligations, Outer Space Treaty is the major treaty, right? 1967 Outer Space Treaty provides you the fundamental principles. Almost all major states are parties to the Outer Space Treaty, including India. Article 6 of the Outer Space Treaty clearly states that for any space activity, whether it is by the governmental entities or by the non-governmental entities, there is a requirement of authorization and continuous supervision. State has to do that. State has to authorize and continuously supervise the activities. Otherwise, it is responsible. There is a state responsibility attributed on the state even for a private space activity. Even for a private activity, we can't say that that's a private agency, I don't know what they have done, therefore actually I am not responsible. No, state is responsible directly for any private space activity. They have to authorize properly. They should also actually continuously supervise the activities. That is why in those countries wherever actually the space activities have started, especially the launch and return activities which I am saying, there is a detailed system of licensing. Look in the United States, UK, European Space Agency states, right? Australia, Japan, all of them have got actually the detailed norms with respect to licensing. And this licensing requires multiple aspects to be complied with, which a private investor would not be able to do it. Private investor is having money, right? He might be having technology, private player, right? But he is not good in law. Just like, say, for example, the patent authorities, how they are making their livelihood. Patent authorities. Inventor doesn't know how to get a patent. They will reach to a patent attorney, isn't it? They will do everything and then they would charge for actually getting a patent. Similarly, here also, licensing. No private entity would be knowing what are the nuances which need to be complied with respect to getting a license. A legal practitioner is required who should basically outline these are the things and this is how it has to be complied with. Right? So that's the first thing. And obviously every state before permitting the private space activity has to license properly. Right? Next, contracts. Any private entity, any private player who would like to actually start any space activity has to enter into contract with a number of players. Like say for example, first getting a land for the lease. Right? SpaceX, if it wants to have a launch pad in some place, it has to get a vacant land. And of course, they can't purchase it. They can't purchase hundreds of acres everywhere, wherever they would like to purchase. Right? They have to get it on lease. Contract with the landowners. Right? Then, installation. It's not like actually building a flat. Right? It's a launch facility which has to be installed in such a way that there is no mistake. It's almost in a foolproof manner that nothing wrong happens during the launch of the return. Right? So it has to be built in such a way. Similarly, maybe the contracts with respect to products. Satellite, they will not manufacture in their own company. Right? They will be purchasing different parts of the satellite from different actually the producers and then they will be assembling and making the satellite. So producers, contract with the producers. Like that there will be multiple contracts which need to be actually entered by the private players. And each of these would involve law, right? Each of these would involve the law because they are not well versed with how to enter into a contract with all those different people without having liability, much of the liability. Right? So that is why they require actually the lawyers to draft the contracts in a proper manner and also whenever the problem arises, advise on the contractual terms. Contractual terms. Right? So licensing and contracts should be the first. Of course, you can say it as two separate areas also actually. So these are the two major things which would come up with respect to the space law practice. Everyone is fascinated. Space tourism. Right? So last year you must be knowing. Who is this? Who is this? Yeah? Vijay Mallya. Does he look like Vijay Mallya? Who's this? No answer? Okay, so you have completely kept the space away from your space inside. Richard Branson, have you heard of him? Who is that? debatable because he reached 87 kilometers above the Earth's surface. 87 kilometers above the Earth's surface. Right? And you know another fellow who followed immediately. Who was that? Jeff Bezos. Right? The CEO of Amazon. Right? Fine. Along with, there are multiple, even here also actually there are other people actually along with him. Right, but the CEOs of the big companies who went to the space for the purpose of space tourism, especially to show that it is safe and to get more and more people signing for the space tourism. Right? Now, while Bezos went beyond 100 kilometers, he went beyond 100 kilometers. Jeff Bezos actually, he wants Amazon Plus in space what? He's the owner of Blue Origin, right? The Blue Origin. So they entered into the space. So it's about 100 kilometers. But Richard Branson reached only 87 kilometers. And as per NASA, which follows Kármán line theory, they say that the 87 kilometers above the surface is the beginning point of space. But not many would agree with that. If you look into most other actually the countries' practice, they say minimum 100 kilometers. Right? It's debatable, there is no concrete line of distinction, but still, there's a debate on that. But whether Richard Branson reached outer space or still was he in airspace is a question, more question. Why is it a more question? Because, let me tell you, that aviation law and space law are the two different sets of law. There is no interconnection whatsoever. I always tell my students that there is something called aviation law or air law. There is something called space law, but there is nothing called air and space law. There is nothing called air and space law because there is no link except the fact that outer space is just next to the airspace. There is no link whatsoever between the aviation law and space law. That is why in my center also I have mentioned the center's name as Center for Aviation and Space Laws. Plural. That's a plural there. It is not aviation and space law. Right? And in fact, aviation law and space law are quite contradictory to each other. They are not even complementary. They are not even complementary. Classic example is liability. In aviation law, any kind of a damage caused to the passenger, carrier is liable to pay compensation. Carrier. Whoever is the carrier, Warsaw Convention is there, Montreal Convention is there, they all provide actually the liability. In the domestic level also, the national laws are there. Carrier is liable. But whereas the space law speaks about the liability of organization, state. It speaks about launching state's liability. Always the launching state is liable. There is no private player's liability mentioned anywhere in the space law. There is no mention about it. So that's the classic example. Plus, you are having multiple other contradictions as well, like the process of registration, exercising of the jurisdiction, application of your laws. All of them are different in aviation and space laws. Right? So in space tourism, first question is, what law are you going to apply? 87 kilometers he went there. Hypothetically, he has done some mischief there and he has come back. How do you try him? Are you going to try him under the aviation law or are you going to try him under the space law? And that's the legal complication. That's the legal complication. Plus, added to that, say for example in space tourism, one tourist commits a tort against another tourist, or one commits a crime against another tourist. Whose law are you going to apply? You don't have any international space law applicable to the crimes in space. Whose law are you going to apply? And how are you going to actually deal with these kind of situations? That brings in multiple complications with respect to space tourism, and also questions with respect to state responsibility will come into picture, right? Whether state is responsible for these private space tourism activities, right? Environmental issues. These tourists go there and later something there and come back. How do you deal with that? Right? Because we know that whatever place is actually a tourist hotspot, environmental degradation automatically happens there. People go there and enjoy that, throw something and come back. Isn't it? So that's why space tourism is another important aspect which is going to bring in a lot of issues from the legal sense, which would also be actually requiring the expertise for the purpose of dealing with them. Liability. I think I told you already about actually the issue of liability, very important. And and every private player is actually skeptical about the liability. Right? Everyone is skeptical about it. As far as the international space law is concerned, it only speaks about the liability of launching state or launching states, plural, singular or plural. Now the definition of launching state is very wide. That's a very wide definition of launching state, especially the liability convention and the registration convention, both of them under the space law. They provide a very wide definition. A state which launches the satellite, state which procures the launching of satellite, state whose facility is used, launch facility, and state whose territory is used. All four of them do come within the ambit of definition of launching state. All four of them. Now, in a private space activity, hypothetically a French private player is actually owning the satellite. But since the launch from India is cheaper, the French satellite company contracts with actually the launch facility owner in India and gets the satellite launched from India. Hypothetically gets it launched from India. Going by the definition, who are the launching states? India and France, both. Right? Both of them are actually the launching states. Now India only has given the facility. Rest of the things are actually managed by the French company only. Right? Once it goes to the outer space, then they will take control. They are actually operating the satellite. Whereas the liability convention is concerned, it categorically says that in case of a joint launching, all the launching states are jointly and severally liable to pay the compensation. There is a joint and several liability. Right? So, all joint launching states should jointly and severally liable. You know the joint and several liability? What's that?
So when the parties are jointly liable for a particular action, like the damages on both the parties together, wherein when both the parties are there are cases of making the parties separately and separately the damages to be paid.
Can you give an example? Any other area where it operates? Tort law? Simple example, anything else? Partnership firms. Right? The partnership firms, every partner in the partnership firm is jointly and severally liable to the full extent of liability. Suppose if the firm's liability is, say, for example, $100,000, there are four partners, right? And if if somebody is claiming that compensation to the extent of $100,000, they can claim from any one of them. There is no requirement of claiming for all four, because the liability is joint and several. You must have heard that, you must have studied this in the contract law. Contract. Now, while applying that into the situation of liability, suppose if this satellite, the French satellite, which has been launched from Indian territory, falls over hypothetically, say Pakistan. Right? Falls over Pakistan or Bangladesh. Also, example is like causes damage there. Right? $100 million damage has been caused there. Pakistan proposed a claim against India. Says that you want to pay $100 million. Can India say that no, I am not liable because it is a French satellite, I have contracted. So that's the kind of a problem. Despite the fact that France or French company owns it, French company is responsible for every launch, operation, everything. Despite that particular factor, liability would be on India. Because the victim has got the right to choose between the two. Right? And obviously, due to the relationships and all, there is every possibility that the victim state is claiming compensation from India only. Now, some mechanism has to be devised for the purpose of shifting this liability. How should this be done? Most things are having legislation, national space legislation, which they are trying to shift it to maybe through the insurance, maybe through the private players, etc., etc. Right? But that has to be done meticulously, and for that purpose, people with law background are required. Government of India cannot fight it. Right? It cannot fight this section. So proper mechanism to ensure that unnecessary liability is not attributed either to the launching state or even to the private players. For that matter, I told you that actually the French satellite has been launched by the private player in India. Okay, a private player. Probably the initial contract mentioned that, okay, so you pay us actually say $10,000 and we are launching from Indian facility. After that, our contractual terms are over, that's it. Right? Over. But ultimately, going by the liability convention, Government of India might be liable to pay the compensation. Now, Government of India might not be in a position to enforce its rights against the French satellite owner but it is in a position to enforce the right against the domestic launch facility owner. Domestic launch facility owner who is in India. So it would try to enforce against him. Right? Now, how can he get it back from the French satellite owner? How can he get back the compensation? What are he going to pay to the government of India? Right? So that should be a proper mechanism, and the people, the people with the legal background, especially in the space law, need to help in terms of doing this fixation of liability. I think you had a question. Yeah, please. Please sit and then ask.
So when we talk about liability and we know that both the states will be liable, in that case, how does a particular state ensure that the liability does not fall back? For example, if India is doing a contract with France, then India must have some mechanism, or there must be some mechanism to ensure that it is 100% foolproof, and at least to the extent we can ensure, so that we don't have to pay some compensation.
Okay. Let me tell you, as of now, it is working on the basis of the contract from ISRO. Right? So whoever is actually launching from India should be contracting with the ISRO. You must have heard about 109 satellites launched at one go, having an international fleet and everything. Right? So nobody else has done like this actually. All those kind of achievements we are saying. Yes, you should be proud of it. But at the same point of time, I have told this to ISRO officials that it is not the fact that other countries are not in a position to launch these many satellites at one go. They don't want to do that because there is a problem of liability. Out of these 109 satellites from different countries, any one of them falls over any territory, you might be liable to pay compensation. Because the liability convention is like that. You might have a contract to contract it out to another player, like the example which I have given. So French satellite, Indian operator is launching. Contract might say that actually liability will be shifted to the French satellite owner in case of any disaster. Contract might be there. Liability convention also says it, especially Article 5, which basically speaks about joint and several liability. It says that you can have a contract with respect to fixation of liability. However, this contract would not be valid against the third victim state. Victim state is not bound by this contract. It can claim compensation from any of the joint launching states. Then, concerned joint launching state, after payment of the compensation, has to ask for the reimbursement from this other state. Right? But every state there will be difficulties, not that easy. Indian government after payment of compensation, how it can enforce it against the private entity in France to get back the compensation? Difficult affair. So that's why the lawyers' involvement in this state becomes very significant, and expertise in terms of fixation of liability and getting a payout in terms of compensating the victims adequately, right, from the corporate part is something which is absolutely required. Right? So that again shows the importance of the space domains. Next, okay, space financing. I have already just pointed out just before, every space activity is a kind of a multi-billion-dollar space activity, multi-billion-dollar activity. Right? The satellite, or maybe actually say having the ground station, taking control of the satellite, all of them will require huge investment. Estimates say that even launching 1 pound of a space object, 1 pound into the space would require $10,000. Placing 1 pound in outer space requires $10,000. Imagine about a medium-sized satellite of 5 to 6 tons. A medium-sized satellite is actually 5 to 6 tons, heavy. 1 pound is $10,000 just to place in outer space. Forget about construction costs, operation costs and everything. Just to place that much money is required. One can imagine how much the investment is there in the space sector. Right? So we are all saying that actually, of course, post-COVID, self-reliance and everything, space sector is one of the major areas. Right? Narendra Modi has basically spoken about that. Actually, there's a requirement of uplifting our space sector and boosting our economy. How? Because there is so much of investment. If your ventures are successful, definitely the whole economy can be boosted. It's like that. But then, this multi-billion dollars investment, can you get it from one single country? If the private players are starting their business, right, maybe in a developing country like India, can those private players get $5 billion or $10 billion only within the country? Obviously not, right? So cross-border investments would be required for the purpose of carrying the space activities. Cross-border investment. Some financiers from maybe Canada, some from say Russia, some from Japan, some from the United States or maybe from UK, from different countries, investors would be investing at different levels. Right? Even actually the say big companies like SpaceX, Blue Origin or maybe Armadillo Corporation, different actually the companies in the international level do have the investment from other countries. They do have the investment from other countries. It is not confined to one single country. Now, any space actor who is carrying on the space activity, by taking the finances from different financiers, they will be having separate contracts with them. There is no uniform contract. Please keep that in mind. All independent contracts. Indian data having a contract with the Kenyan data, same data having with the Japanese data, right? Russian data, US data, like that. What are the terms and conditions in the contract? No one knows. No one knows. Primitive contract. Right? There is a clause with respect to confidentiality. Only the debtor knows all the contracts. That's it. The one who is carrying on the space activity knows all the contracts. And in every contract, they would be agreeing for different applicable laws. Applicable laws for their contract. Say, for example, Indian creditor vis-a-vis actually the Indian debtor vis-a-vis the US creditor. They must have agreed that US law is applicable in case of any default. With the Canadian creditor, he must have agreed that Canadian law is applicable. Japanese creditor, he must have agreed that Indian law is applicable. Russian creditor, Russian law. Like that actually. So there might be a possibility that the different laws have been agreed upon in independent contract with respect to default. Presume that an Indian debtor has got finances from 10 different creditors from different countries. 10 different contracts he's having, 10 different creditors from different countries. Now the Indian debtor, the space actor, right, so probably he fails to carry on the activity smoothly and he is not in a position to pay back to these creditors. He becomes bankrupt, right, not in a position to pay back. Every creditor want to get back the investment as soon as possible, isn't it? Once actually there is a possibility of liquidation, every creditor is interested in enforcing the rights. Are you getting it? Right? So they are interested in actually enforcing the right. Now, as per the contract, they will be going by respective laws. They will say that, okay, enforce US law. US creditor would say US law. Canadian creditor would say Canadian law. Japanese creditor would say Indian law. Now, what is important is actually how exactly you are going to synchronize the payment back to the creditors. Who is going to get back first, who is going to get second, who is going to get third, fourth, fifth, like that. This is very important because if the private player has taken the finances to the extent of $2 billion, right, from someone 200 million, someone 500 million, 800, like that, totally 2 billion he has taken the finances. Towards the end, when he actually fails to pay back, his asset may be worth of only $1 million. Right, there is no rate of fail generation. So therefore, his assets are only worth of $1 million. For creditors, who is going to get back first is important now. Those who are towards the end in terms of the sequence, they will not get back the money. After 1 billion, there is nothing else left. Simple logic. Right? After 1 billion actually has been paid back to the creditors, there is nothing else left with the debtor. So from where he is going to pay to the remaining creditor? So everyone want to jump into the equation, want to actually be in terms of actually the top of the priority list. Top of the priority list in getting back the investment. This priority list is different in different countries. Like some state might have the priority on the basis of first come first serve. Whoever is the first investor, get back the money first, second, third, fourth. Some state might have a distinction between the registered creditor and unregistered creditor. They might have a system of registration. Whoever registered first will get back first. Unregistered would not get. Some states might have secured creditors and unsecured creditors. Distinction. You must have heard about that in company law. Right? Secured creditors and unsecured creditors. Secured would get first, unsecured get subsequently. So this kind of differences are there in different jurisdictions and you will have problem in terms of enforcing the rights of the creditors. Obvious resort is to the lawyers. Somebody who has got expertise in this particular field so that the creditor can get back the money as soon as possible. Everyone would be in need of such kind of a lawyer. Right? Space finances is one of the most significant aspects wherein a lot of practice is going on at present also. Anyone who is interested, go through actually unit Dhruva. Right? UNIDROIT. It's a unit Dhruva, it's a French term. You must have also studied in administrative law, Droit administratif. It is not Droit administratif, it is Dhruva administratif. Right? It's a French term. So like that UNIDROIT is unit Dhruva. It's known as that. So you can go through the unit Dhruva's work. There is a lot of things which is going on with respect to financing. Not just space financing, but also aviation financing. So please go through that, and that's an enormous scope for the purpose of practicing in the field of space financing. Yes, please.
So when we know that there are private creditors of different countries giving credit to the one in particular one country, and then when the debt is not satisfied completely, then there will be creditors who will be still waiting in the line of in the priority list. So in that case, even the international relation between the country would come into play, and in that case, how will state react to it, like according to the space?
No. As of now, the state should not react to these type of activities. The private actually investment from other countries in your country in terms of the exercise of the right by the creditors, etc. States usually don't react to that actually, right? Because it's more of a private affair, and whatever rights are available, states need to allow. The system also speaks about that. It says that even if you don't recognize remedy under the municipal law, still you have to recognize it under the Unidua system. Once you become party to the Unidua system, you have to recognize it like that. So interstate-state relationship would not come into picture. It would be more informed in terms of respecting the rights of the creditors on the basis of the priority. Right? So, but anyhow, at the end of the day, actually the investors or the creditors would definitely require the assistance of a lawyer. That's what I'm trying to tell you. Right? So all private investments, wherever it is actually, assistance from the lawyer is definitely required in terms of the getting back the money by the creditors. Next, property rights. Have you heard of this? Property rights in the celestial bodies. No? Yeah, moon and other celestial bodies. Have you heard of it? Not very much. Have you heard of issue of property rights in the celestial bodies? Of course, there are plans of the human habitation which are going on actually. You must have seen the NASA's plan and all with respect to human habitation in the future and all. That is one part of it. Property rights issues would come up. Apart from that, there are also private players who have claimed property rights over the celestial bodies. Have you heard of a guy by name Dennis Ho? Dennis Ho. Not the Dennis the Minas, Dennis the Ho. Have you heard of him? No? Okay. So he has a website called www.lunarembassy.com. Please go through it after this session, definitely. You need to go through it. Lunarembassy.com. Lunarembassy.com. Right? Even if you Google also, you get it. Lunar Embassy. Absolutely. You can purchase actually the parts of the moon or the celestial bodies. Seems to be actually okay. Is it true? Is it true? He is. And he is doing that since the beginning of this 21st century. From 2000 onwards actually he is doing it. And he has already sold the property to more than 7 million people across the globe. 7 million people. Yeah.
Sir, but like having property rights within the space, like, is there not a direct violation of the outer space treaty?
I have always advocated that it's a direct violation of outer space treaty, but unfortunately, who has taken action against Dennis Hope till now?
Are like celestial bodies under Article 1 and 2 of the outer space treaty?
That has been my argument, and primarily actually Article 2, the national non-appropriation would also include a prohibition on the individual appropriation. The prohibition is there, but unfortunately, most of the Western scholars have tried to argue that there is only prohibition on national appropriation, but there is no prohibition on individual appropriation. That's a wrong argument, absolutely wrong argument. You can also refer to my last International Astronautical Congress paper. It's available in actually the colloquium reports, the International Institute of Space Law's colloquium reports. So my paper was primarily on that to say that no, absolutely this is not permissible actually, right? But whatever it may be, this business is going on. and it's a business worth of more than 10,000 pounds per day. 10,000 pounds per day. Right?
Is it even considered a property?
He is considering it as a property. He has his own arguments. There are multiple arguments. He has registered this in what is called as San Francisco County Seat Registry, right? A county seat registry. Then he has copyrighted his claim, and he says that he is the first claimant. Nobody else has claimed these celestial bodies earlier, so therefore it belongs to him. All those ridiculous arguments he puts forward with respect to testifying his claim. And more than that, there are people who are purchasing the property. That is the problem. More than 7 million people purchasing property means what? Right? Maybe one of the biggest frauds. That's it. Right? So that's why actually the problem arises. And let me just actually complete this and take you further. Not just him. Right? Of course, he has already actually sold the different the portions. You can also go to the lunarembassy.com to find out the map of these different celestial bodies, which portions are sold, which portions are available. All these fascinations are there in the Lunar Embassy's website. Taking clue from him, there are other people also who started actually all these things. Trading properties. A guy called Nemitz, right? Nemitz filed actually a case against NASA saying that he owns an asteroid by name asteroid 433 Eros. He said that he owns that asteroid, and the NASA's space object, when it landed on this particular asteroid, right? NASA's space object near Schumacher, it landed on actually this particular asteroid. He wrote to NASA saying that you need to pay me the parking fee. Right? Because it belongs to me. And he went to the court, to be very precise. He went to the US court also. Thankfully, the US court rejected this claim. That's a different thing. But this kind of fascination is going on. This kind of fascination is going on. Plus, this guy, the Sylvia Langevin, the fellow, he went to the Superior Court of Quebec asking for a declaratory relief that all celestial bodies belong to him, along with the space between the celestial bodies. He asked for a declaratory relief from the Superior Court of Quebec, right? Putting forward the argument that he is the first claimant. Because see, historically, all this property on the earth and all, how it has been allocated. But first claim, isn't it? First come, first serve. First claim, supplemented by the corpus possibility, that is actually occupying that place and then fencing the territory and all those kind of things. So our ancestors got right by virtue of that. First claim is the primary rule. So he says that he is the first claim and nobody else claimed all celestial bodies. Right? So that kind of actually the things are going on with respect to property right issues. Of course, this has been rejected. The Superior Court of Quebec basically said that no, there is no such kind of a right available to Langevin. But the problem is that still the Dennis Hope is continuing this business. Dennis Hope and few others have also started online. You can find those kind of websites. They are still continuing, and almost in all countries they are actually selling the property. That is the biggest problem. And I'm pretty much sure that in the course of time, these 7 million people, they will all be having 7 million litigations. Obviously, they will have litigation. They will say that our hard-earned money, we have invested that in what the state was doing earlier, why the state did not prohibit this. Right? That would be one question. Not just that, if you look at the list actually, all Hollywood, Bollywood actors, even actually the politicians, their ancestors, all of them, their name is there.
They are purchasing now that he is no more. If his father claims that property under which he is
Definitely there is no answer for this, because actually I should say that even if Sushant Singh was actually alive, if he is claiming property right over this, under what law, under what jurisdiction, nobody knows.
this entire thing is just an utopia.
Absolutely, absolutely. But unfortunate problem is that actually United States has not taken action till today. US should have taken action against him. And Article 6 says that there is a state responsibility for every private space activity. This is also an activity within that government.
Now that there is a dispute arising, Sushant Singh Rajput should have will ask India and other states, because under the space law, the state is responsible for any dispute.
No, that is true. But in fact, from the perspective of India, it might not fall within the ambit of a space activity. Right? Article 6 says state is responsible for national space activities. Right? Which may be carried on by the governmental or non-governmental entities. That's what it basically shows. Here, Sushant Singh has only purchased the property. Right? There is no space activity conducted by him. But whereas Dennis Hope is actually claiming property over the celestial bodies. that would come in the domain of the space sector. So, US has a responsibility definitely under Article 6, and there has been actually statements issued by the top bodies like International Institute of Space Law also, that US has to take action and condemn these kind of activities. Right? 2003 and 2009, you can find out actually the declaration by the Board of Directors of IISL, International Institute of Space Law. You can check in the website also, you will be able to find it out. They have condemned this kind of activity, but unfortunately the US has not taken any action. Right? Litigations are bound to happen. You have anything else to ask?
So I just want to, I'm just curious about this thing, that what are the rights that they are actually showing it to the people or when they are giving money? And
Right. If you go through the Dennis Hope's lunarenbassy.com, you can find all kind of fascinations. All kind of fascinations. Even that copywriting is claimed. Makes no sense. I mean, I have countered each of those arguments actually, whatever he has put forward. So in my paper it is there actually. If you want, I can share that paper with you actually. Or maybe anyone else who is interested. So each of the argument of Dennis Hope has been countered. There is nothing which is actually legal. But the only concern is that why United States has not taken action till today. That's the only major concern. Of course, in China, the administration that has actually suspended the license of Lunar Embassy in China, and they have also actually imposed a fine against the Lunar Embassy. The case went to the court, but the court said that no, the fine is fine because it's just a fraud. There is nothing more than that. So the Lunar Embassy has been stopped in China. But in other countries, it has not been stopped. United States is also not taking action. That's the concern actually. Okay. Yes.
Sir, even if I take, like, just one question, even if I take from, like, what you said about this person claiming parking rights, parking fees, and even if I take for a second that there has been the appropriation of property in space, it has been given, and I take it that they are allowed to take possession of the property. Now, someday, if another state lands an asteroid, a satellite, for example, on that property, and that person is like claiming for parking fees or for damages to his or her home which is built in space, would that also not be possible under the Outer Space Treaty? Because
absolutely, see, none of these things are permissible under the Outer Space Treaty, to be very precise. But misinterpretation is that what is prohibited is only national national appropriation, but not the individual appropriation. That's a misinterpretation. Yeah.
Sir, but again, under national, so but does Article 1 also not say that it must be free to all the states to explore equally?
Yeah. Freedom of exploration, use and scientific investigation, which is also there under Article 1, that would also basically be infringed upon. But more than that, I should say that Article 2 itself, I thought that actually it would be boring for others, that's why I did not explain. Let me actually clarify this to you. Right, what is that? Article 2 says that there shall not be any national appropriation by claim of sovereignty, use or occupation, or by any other means. These are the exact wordings of Article 2. Now, some of these Western scholars say that what is prohibited is only national appropriation. I as an individual, I have a right to exploit these resources or maybe claim the property rights. Appropriation is permissible. But this is ridiculous, especially because we have to look the property right concept from both common law and civil law perspective. In the common law countries, can I own a land property without my state owning that? Can I own a property without my state owning it or having sovereignty over it? Absolutely not possible. Absolutely, because actually in the common law countries, is it time? Do you have anything else after this? No? I can extend, right? No problem, right? Okay. So in the eminent domain, exactly. The doctrine of eminent domain, or even otherwise also actually, see in the common law country, all the property rights are derived from the state. I enjoy my property because the state has granted it to me. Right? State has granted to me. So when my state is not having any property right, I can't own it. I can't own it. So that's the concept in common law. Now in the civil law countries, property can stand independent of actually state right. That is possible because what it says is that anybody can go and occupy a terra nullis, something which does not belong to anyone, and put in labor for the development, right? And once it is developed, the state can recognize the labor whatever has been put in for the purpose of conferment of the property rights. And even if the state does not own it, still it can recognize the property of an individual. That is possible actually in the civil law country. But again, an individual from the civil law country can't own the property in the outer space and celestial bodies. Why is it so? Why is this so?
Because that person will not be able to put in labor for the development of that property.
so they have to go there and occupy and put in labor for the development. Number two, more than that, it is possible only when something is terra nullis.
Also, no country owns the space.
Yeah, it is not terra nullis. Rather, actually, we have the principle of province of all mankind under Article 1 of the Outer Space Treaty. Province of all mankind. It belongs to the whole mankind. Right? Which is a variant of the res communis regime. Not res nullius regime or terra nullis regime. So, it's not that it does not belong to anyone, rather it belongs to everyone. So that is the reason why even a person from a civil law country can't go and occupy the celestial body, can't put in the labor, can't claim the property rights over it. Right? So these are the things. Anyhow, so I think probably I gone too much into it. Whatever it may be, please keep in mind that the property rights, whatever are currently there, are definitely not permissible under the international legal regime, but unfortunately is going to fuel a lot of litigation in the course of time. Since US has not taken action, more than 7 million people have purchased, definitely a problem will be there. Yeah. Last two things before I wind up. Celestial mining. Another very closely connected issue. Have you heard of actually the mining of the resources being permitted now in the celestial bodies? I'm not telling you about Earth. Haven't heard of it. Okay. It all started with 2015 United States Asteroids Act. 2015 Asteroid Act, which basically says that any private player can go and mine the resources in the celestial bodies and own them as well. You can go through it. 2015 Asteroid Act of the United States. 2017 Luxembourg has come up with the same law. 2017. 2020 UAE. 2021 Japan. Japan is the fourth country to have the law of the space resources. Private players can mine the asteroids. Private players can actually mine the resources and own the property rights. Right? Definitely violation of the space treaties. There is no doubt. I have argued about that as well actually. But now there is another trend. Have you heard of Artemis Accord? Artemis Accords. The United States has come up with what is called as Artemis Accords for the purpose of exploiting the resources of the moon. And they have called for actually the different countries' cooperation. Already many countries have signed up. Artemis Accord actually is a plan for the purpose of extracting the resources of the moon individually, quite against the spirit of the space treaties. Not just the Outer Space Treaty, you have the Moon Agreement. Of course, Moon Agreement has not been signed and ratified by many countries. US or maybe major countries have not signed and ratified. But still, it has a very strong concept called common heritage of mankind. Common heritage of mankind. Right? And it says that if you want to exploit these resources, you have to bring in international regime. International regime, not domestic regime. And then equitable sharing of the benefit. That is something which is absolutely essential because these are the charities of the nature. And when you say charities of the nature, all of them should belong to everyone in the world, not just to the developed countries' enterprises, private enterprises. Right? That is the thing. But unfortunately, individualistic regimes are going on now. Artemis 1 launch is happening this year itself. They are launching the first satellite to land on the moon for the purpose of mining. And they are doing it this year itself. Just actually keep a track of that online. Yeah.
So when we talk about the fact that it should be on an equitable and more, then the requirement of every country would be different. That will also be
Right. Yeah. Of course, there is difficulties. But in fact, actually, what they are saying is that there is a requirement of striking balance between two things. One is efforts of the developed countries. Whoever has actually put in the efforts in terms of exploitation of the resources and deriving the benefit, you have to take into consideration that as one of the parameters. Second is need of the developing countries. Need-based classification. Right? There are poor people who would require actually the benefit coming out of that for the purpose of their sustenance. So striking balance between the two, how exactly we are going to do is questionable, but that is what is the mantra behind actually equitable sharing. Right? Anyway. Okay, so the whole celestial mining is going to be one of the biggest things, and since it is being legalized now, there will be a lot of issues. I think he was telling about somebody actually going there, landing there, and another person wanted to exercise the right therein also. Freedom of exploration use for everyone. Right? If US or maybe SpaceX is going and mining one region, somebody else also want to go there and mine the same region. How would you balance the rights of them? Right? Lot of issues, lot of actually the litigations, and probably what we have evidence during the gold rush. Once again, the same kind of a stuff would happen in this individualistic approach of the national space laws. Right. Last thing, quickly let me wind it up. IP issues. IP. There are so many intellectual property rights issues which are coming up with respect to space activities. Be it the copyright or broadcaster's right. Broadcaster's right is part of the copyright, you know, right? Trademark issues. Different companies are having issues about the trademarks. Confidential information. An employee of the SpaceX actually leaving SpaceX and joining, say, Armadillo Corporation or Virgin Galactic, he will be carrying technology to the competitor. Confidential information, how do you save it? Right? It's a big problem. Last, most significantly, the patents. Patents in space. Right? Because actually, see, now you have the stations. The International Space Station already is operational. China has its own space station. Chinese station is there. There are plans for the purpose of having the stations on the moon. Russia and China have come together to have a lunar base. Right? So there are many developments which are going on with respect to space stations to carry on the inventions directly. Can you grant the patent rights for that? Debatable, because patent is a monopoly right? Right? Monopoly right? Whereas the space law is advocating for common rights. Province of all mankind, common rights of mankind, all these things are there. How can you allow a common rights region being used for the purpose of creating a monopoly right? Debatable. Then, more than that, suppose if actually an invention has been patented on the earth, right? Patented on the earth. Somebody goes to the International Space Station and duplicates that invention. There is an infringement. Who has the jurisdiction to try this infringement? Not in your territory. It's in International Space Station or maybe on the moon. Who has got the jurisdiction? And more importantly, whose law you are going to apply? Do we have an international patent law? Somebody may say TRIPS. I also teach trade law. So, yeah, TRIPS is absolutely not an international patent law. TRIPS only provides you the minimum basic standard to be followed by the countries. That's it, nothing more than that. Right? This much of minimum intellectual property rights protection has to be granted. That's it. And IP rights are individualistic in the countries. Respective countries need to come up with their own law. Right? TRIPS is not actually the international the patent regime or international actually the copyright regime or anything else. It's just the basic standard which is provided that. So you don't have an international patent law. All are municipal. If you want to protect actually a patent in India, Indian law. If you want to protect it in US, US law. Japan, Japanese law, like that. What law are you going to apply in international space? Or what law are you going to apply on the moon? Right? So there would be a lot of actually the complications with respect to this. And already many litigations have come up in the countries like United States as well as European space agencies actually. So therefore, IP issues are also going to be another major area of the practice for a space law. Right? This is also another major area. Yes?
So I was wondering, on this particular aspect, it's written on high seas, we go about the ships, the flag of a particular ship. Same principle can't be applied in the space when it comes to patent law or infringement.
Right. Okay. Let me tell you. As far as actually the space treaties are concerned, we have Article 8 of the Outer Space Treaty, which basically speaks about jurisdiction and control in the state of registry. Similar to that of what you can find under the high seas. Right? The flagship has got the jurisdiction over activities on board the ship. But whereas there is a minute distinction between Article 8 of the Outer Space Treaty and the flag state jurisdiction. Flag state jurisdiction is confined only to activity on board the ship. If somebody jumps into the sea, does something there, flag state jurisdiction is not applicable. Nationality would come into picture, or maybe something else would come into picture for the purpose of jurisdiction. Whereas Article 8 says that state of registration shall retain the jurisdiction and control, these are the wordings, shall retain the jurisdiction and control over the space objects and the personnel thereof. It is not thereon, personnel thereof. That means, even if they are launched into the outer space, if they go out of the space object also, they are subject to the jurisdiction of state of registry. And this is one of the biggest problems with respect to exercise of jurisdiction. How? Let me simply explain. Say from state A, say for example from India, a particular astronaut has been launched into the International Space Station from India, and India is registering that space object. India is registering that space object. By virtue of Article 8, India has got the jurisdiction over the space object as well as that astronaut. It's a quasi-territorial jurisdiction as well as personal jurisdiction, not territorial. Quasi-territorial on the space object personal on the personal level. So who is going to the outer space, right? The astronaut. On the astronaut also there is a personal jurisdiction. India has got both the jurisdiction. Now he goes to the International Space Station. Might be entering into the module which belongs to the European Space Agency. European Space Agency module, right? European Space Agency module, already any module for that matter has been registered in the respective countries, right? In whatever country actually, whatever country has contributed, that country has registered the respective module. ESA has registered its module. He enters therein, infringes the patent. Whose law will apply? Or who will have the jurisdiction? Is it European Space Agency states or India? India has got the personal jurisdiction. He still belongs from the Indian satellite, which has been actually registered by India, right? So India has a personal jurisdiction, but the European Space Agency has got a quasi-territorial jurisdiction. And then in European Space Agency also, which among those countries is going to accept the jurisdiction? It's an organization, right? It's an organization, and they don't have the uniform patent law. They don't have a uniform patent law. Even in Europe, you don't have a uniform patent law. So now, who will exercise the jurisdiction? Whose law you have? That is the complication. That's the complication. So, a lot of litigations would definitely arise out of these problems. And definitely, I think 21st century definitely belongs to space law. Right? It belongs definitely to space law. I have always advocated in every forum that this is actually the space law era. Right now, we are not in a position to understand that because we are sitting in a corner of the world wherein we can't see these things. Right? We can't see these things. And when I asked all of you about some general knowledge questions, you said that no, we are alien to it. Because actually, it's true. In India, we haven't thought about it. Right? Despite the fact that there has been actually so much of a, chanting of the mantra that we have to go for a space economy, developing more and more, etc. We still are supposed to have a national space legislation. We still are supposed to have private entities coming in and investing here. That's the reason why we are not in a position to visualize it correctly. Otherwise, I should say that there is nothing else which would unfold you more opportunities than space law at present. Right? Of course, it requires hard work. Maybe one of the best institutions one need to join and get actually the degree, requisite degree, maybe the McGill, Leiden, University of Nebraska. Now even Luxembourg has got actually the space law branch. Even Sharjah University has come up with actually a space law branch. Like that, many other universities are also coming up. So having expertise is absolutely required, and all these things are not at grab actually without having expertise. You need to have expertise, and of course, space law affords you a lot of opportunities. That's all. Thank you so much. Yeah.
Do you need to be well versed in physics or science to understand?
Absolutely not required. Absolutely not required. Even though actually I did +2 in science, that's a different issue. I didn't think that actually it is in any way required for the purpose of my understanding of space law. Right? To a very limited extent, for the purpose of understanding what kind of technological developments which are happening, how should we interpret that in the context of development? That's it. Nothing more than that. There is no requirement of actually having any science background. Right. So I think it's time already. Thank you so much. Thank you so much. Okay.
I take this opportunity to thank you for such a wonderful session and giving us insight on space law as a career option, which will definitely help many students in deciding their career further. Before delivering a vote of thanks, I'd like to say that the university bus will be leaving at 5:10 p.m. On behalf of Xavier Law School and the core committee of XSLAJ, I take this opportunity to extend my heartfelt gratitude to our esteemed guest, Professor Dr. Sandeepa Bhat, for taking out time from his busy schedule to grace this event. Thank you for inspiring and encouraging us with your words in today's session on space laws and opening a new door of opportunity for the students of Xavier Law School. I would like to thank the Honorable Vice Chancellor and the respected Registrar for trusting us with the wonderful opportunity. I would like to thank the Dean of Xavier Law School for the constant support. It is an honor for me to get the opportunity to thank all the dignitaries present here. I would like to thank the convener of XSLAJ, Dr. Animesh Das, for guiding us throughout. I would like to thank all of you present here for making the time to be with us today and helping us make the very first offline episode of the monthly talks Colawquia a grand success. Lastly, I would like to thank the students for participating and making it a success. Thank you one and all. Until next time, or should I say the 7th episode?